Good evening. Good evening. Gentlemen, are you ready? Okay. This meeting will come to order. This is the Zoning Board of Appeals, December 2018 meeting. Please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Okay, roll call, please.
Mr. Soda advised that he cannot attend tonight. Mr. Hirsch?
Yes.
Mr. Casey?
Here.
Mr. Tizzola?
Here.
Ms. Ferrante?
Here.
Ms. Valcott?
Here.
Mr. Dubois?
Here.
Thank you.
Thank you. Also present is Stephen Harris, our zoning officer, David Sokas, our city planner, and Meg Green, our recording secretary. If anyone feels that there's someone on this board, a member on this board, that might be a conflict of interest to your application, please let us know. Item number one this evening is postponed. Mr. Harris?
Yes, that's correct.
Okay. Item number one is postponed. All right, so for our board this evening, Mr. Hirsch, you'll be a voting member. Mr. Casey, you will also, please. Okay, thank you. Okay, item number two.
Item number 2, 162 Kings Highway, MBP 6741, BD Oscar Parente Esquire for Robert Harrington and Daryl DiPaolo, appellants, regarding the lot of Anastasia Blake, owner, Section 9.2.1, appeal the decision of the city planner in a free split letter dated September 18, 2018. Applicants became aware of the letter on October 22, 2018.
Good evening, everyone. Kim Coleman for the appellants. Again, I thank you for keeping this open.
Okay, would you please identify yourself again for us, please?
Kim Coleman, C-O-L-E-M-A-N, Attorney Kim Coleman. My office is 112 Broad Street, Milford.
Okay, thank you.
Last month, we left off with basically two issues. One of them was the concern about the actual measurement of the land. Did it include the sidewalk or not? We went out and measured it ourselves. It's 50 feet exclusive of the sidewalk. But there's some other issues that have since arisen. The other issue that was of a concern was, where's the jurisdiction here? I've been told that they should have filed with the Superior Court, and I keep being told that it's by state statute. So I went through the planning and zoning regulations, and nowhere in there could I find anything that pertained to when the city planner makes a decision how to appeal it. I did find that the city planner can have the same duties as the zoning enforcement officer, and under both the planning and zoning and the state statute, the normal route would be to appeal to the ZBA and then go to Superior Court.
Excuse me, where did you find that out, what you had just said?
Well, in the zoning regs, 8.2 defines what the zoning enforcement officer does. 8.22 defines that the chairman of the P&Z, city planner, and assistant city planner can enforce the regulations in the same manner as the zoning enforcement officer. And then under 8.5, one of the duties of the zoning enforcement officer is to approve applications. Under 9.21, the ZBA hear and decides appeals when there is an order of decision or decision by the zoning enforcement officer. If you were to put the city planner in as the zoning enforcement officer, it would go from city planner, ZBA, Superior Court in Connecticut. I looked through the general statutes, and if I could give you a handout, it might explain this a little bit more.
Mr. Harris, would you like to see a copy of these, the letters, please? If we could pass one down. Gary, if you could pass that down there, please. Michael. Eton. Okay. Do you have one?
No.
Okay. You have one? You do? Okay, okay. Here you go. Okay?
I
Okay.
actually
Go
called
ahead,
Planning and
continue.
Zoning today and asked them where I could find in the zoning regulations where it defines a free split and how it would be appealed. And I met a very lovely person. She's not a lawyer, I understand it. She says, I don't think it's in the regulations. It's in the statute. And I said, can you tell me what statute? She goes, oh, no, I don't know. It's in the statute. So I pulled out the Connecticut statutes. Title 8 of the Connecticut General Statutes deals with the land and zoning. And basically what Connecticut General Statutes is a framework, a legal framework for what planning and zoning are enabled to do procedurally. Under 8-8 of the Connecticut General Statute, it specifically says you can appeal to the Superior Court or a zoning board of appeal. What you're seeing in front of you is this first page. This was actually presented by the applicant's attorney, and it clearly states this division is a lot. The division of this lot is a free split pursuant to Connecticut General Statutes 8-18. Attached behind that page is 8-18, which is the legal definitions of what a commission is, what a zoning board is. I searched for hours today any kind of state regulation, statute, that defined a free split and when it could be done. There isn't. It doesn't exist unless I missed it. I actually used CaseMaker and Google Scholar. No definitions. There's only about 4 or 5 other municipalities in Connecticut that actually have this free split. So then the next issue becomes, and if you look to the last page, it's the warranty deed provided by the applicant's attorney, because it has to be a deed prior to 1929, which is when the zoning regulations were adopted by Milford. Though this states its boundaries and it's 50 by 100, there is a covenant written there. It is understood and agreed that no building or portion of any building shall be built or maintained on said premise that shall approach nearer than 14 feet to the street line of Beach Avenue or nearer than 12 feet to the street line of New Haven Avenue, now known as Kings Highway. When you look at that covenant, you now have 36 by 88 feet of usable property to build on. Under a BD1, the minimum size for a lot, and that is zoning regulation 3.8.4.1-1, the minimum for a lot is 25 by 80. It's our understanding that, actually, we called CADIC. CADIC is the Connecticut Attorney Title Insurance Company, and we spoke to their counsel, and we explained what was on this, because covenants can be different. What we would do now was not what we used to do over 100 years ago. But having read the covenant to them, their opinion was that the covenants as these were to preserve the character of the lot. And the covenants like these usually run with the land. So this carries forward to today. So where are we today? Day 2 of the hearing. I'm getting no guidance from the statutes. I'm getting no guidance from the Milford Planning and Zoning regs. And in fact, there's a deficiency in the planning and zoning regs because it doesn't talk about a free split, doesn't say how to appeal, there's no notice to people. And I explained the issue with notice before with my clients. They had continually gone to planning and zoning. They had talked to City Planner Solkis. They were told to keep calling, you'll get notified, check our website, and all of a sudden this free split kind of went in under the radar and nobody knew about it. So the question of is this free split legal is actually a legal question. If it was to be determined that the usable lot was only 36 by 88, you could not free split it. So where do my clients, the appellants, go from here? A decision issued by you, there's various things we could do. There is a process, I believe, where we can make a complaint with the zoning officer. And he would have to make a decision, and then it would come back to you if we didn't agree with the decision, or if the applicant didn't agree with the decision. So it would maybe make a whole nother process back. My clients could file in the Superior Court for a constitutional violation of procedural due process rights because of no notice. And they could also ask for a declaratory judgment on if this usable property is 36 by 88, thus cannot be free split according to the regulations under BD1, which require 25 by 80. Or maybe we could do something else. I know that you have corporate counsel for the ZBA, and I don't think this issue is going to go away. I think there's going to be more of these. I've lived in Milford over 50 years, we'll say. I've never heard of a free split, and I was active in politics, and I don't think residents realize what this is. And I know a lot more people would be concerned when it comes into their neighborhood, especially now with all the building going on. And I don't want to challenge or threaten or anything. My clients would just like to resolve this. They wouldn't mind a big one-family house, two-family house, just not two houses 21 feet wide on the properties bordering a neighbor and a sidewalk on Beach Avenue. So again, I would ask that maybe you consult your corporate counsel. And hopefully, I would love to work it out. I've talked to their attorney. He said he was going to be here. I don't know if he's here. And we discussed this at length. We, of course, disagree because that's what lawyers do. It can be read a couple different ways. But I think we'd all would like to resolve this with the least amount of stress, time, money. It's very important to my clients and others in the neighborhood who I've talked to. Does anybody have any questions?
You know, this all gets back to what we had even discussed the last time. I mean, you're asking us to find another way to help you with this appeal, but the original appeal was not in a timely manner. And again, the ZBA, this board, we don't have the authority to overturn, whatever has been put out by the planning and zoning. So that's kind of our position on it, and we appreciate your arguments on it. But maybe if we have some questions for you, at that point there, then we'll listen to the other side of it, and some of the things that you had brought up in your letter, we can, we can ask those to be addressed, but
And I know your jurisdiction was an issue, and I would disagree that you don't have jurisdiction over a city planner decision. All decisions from the zoning board, from the planning and zoning, according to state statute, can be heard by a ZBA. Problem is, the administrative actions of planning and zoning don't define this. And it's a real shortcoming in there.
The appeal should have been against the planning and zoning board, and should have been to Superior Court.
You know what, unfortunately, my clients came down themselves and filed this, and they filed it out of desperation because they had heard so many different things. They had talked to the city planner on no less than 5 occasions. Yeah, we're gonna have a hearing, yeah, we're gonna have a hearing, yeah, we're gonna have a hearing. And then he slides it through. You know, that's not how I was brought up in Milford. But I would disagree. I believe you do have jurisdiction. Is it timely? It's timely from when they had notice. They filed it the day after they got, or the day of notice. So I could argue that in a court of law with, absolutely. And especially because there's nothing in the procedures that defines what to do when a free split is determined by a city planner. So I would disagree with you on that. And I would really hope that this board would consult their lawyer prior to making these decisions. I think it would be very important for all of us to look at this.
Okay, any questions for Attorney Coleman? No?
Thank you.
Anyone else speaking on this appeal that hasn't, maybe at our last meeting? Anyone else speaking on this appeal? Were you at the last hearing by any chance?
No, I was not.
Okay, thank you. Please state your name, your address, please.
Barbara Wagner, 29 Clinton Street. I'm going to read a letter from Warden Ed Benessi, Borough of Woodmont. I have copies for you. Referencing 162 Kings Highway. Dear Mr. Tizzola, the Borough of Woodmont, acting through its Board of Warden and Burgesses, like other agencies having jurisdiction in our corporate limits, is also charged by statute and charter to protect the health and safety of its residents and their property. We are often asked to comment on matters being addressed by other boards or commissions in the city which affect the residents of the borough. Our board has reviewed the application of Stacy Blake for a free split of the above property from one parcel currently 50 by 100 to 2 parcels of 25 by 100 each, and to build 2 homes right next to each other, right out to the street lines where one presently exists. After review, the Board of Warden and Burgesses has made a finding that the proposed plan presents significant health and safety hazards, including, but not limited to, fire safety because of the closeness of the proposed buildings, water runoff and sewer service in storm situations, parking for vehicles and traffic line of sight concerns, increased congestion and density in an area which has been primarily of residential character for decades and no longer business use. On the subject of the street lines, it appears that the 1927 deed submitted with the application, albeit being dated before 1929, contains private land use restrictions requiring greater street line setbacks than shown on the plan. The property has been continuously used in accordance with those restrictions, and the property split with the 2 buildings would create a non-conformity. The adoption of zoning regulations did not abolish any existing private land use or builder subdivision covenants. For the above reason, the Board of Warden and Burgesses of the Borough of Woodmont respectively request that the pending application be denied. Sincerely, Edward W. Benessi, Jr., Warden. Thank you.
Thank you. Would you gentlemen like to take a look at this? It's just what she had read to you, so. Okay.
Good evening. My name is Kate Harrington, and I've resided at 160 Kings Highway for 25 years. I want to implore this review board to consider not what can be done at 162 Kings Highway, but what should be done. What should be done? This lot has been a single-family home on it for close to 100 years. This is the intended use of the property. That it sits on a BD zone does not change that fact. I understand that neighbors don't always agree, and that is why you exist. But a person should not be granted a green light on an issue of this magnitude without full transparency to all the neighbors. My husband came into the Planning and Zoning Office in August, if you want to talk about timeliness, in August. And he expressed his intention to contest this subdivision. He was told by the office that there would be a meeting where he would publicly get to make his case and to check the docket online for the meeting that would be sometime in September. He did this, but the meeting never appeared on the docket. We now know that this was because the meeting requirement was waived. Only when my husband asked the workers outside 162 Kings Highway one day did he learn of the action on this property. Apparently, this was published in the New Haven Register, a newspaper. Yes, a newspaper in today's day and age, where I can know something around the world in my hand within seconds, a newspaper. Fine, that meets the minimum requirements. If that's something you're comfortable with, it doesn't sit well with me. We did not read the newspaper, nor were we directed by the Planning and Zoning Office to do so. We were directed to the website, which made sense to us because, you know, websites 2018, and there was nothing there. The fact that I can know about this in this way, finding out by workers, not by this office, not by a letter from the homeowner, nothing. It does not sit well with me. Newspaper, I'm going to go ahead and call it what I see it as. That's buried. It's buried news. I am not asking for special treatment. I am requesting proper treatment. I am asking what should be done. My husband was misdirected by the Planning and Zoning Office, in person, by the staff there. An honest mistake? Perhaps. Should it be corrected? Yes, right now, if you listen to the arguments that we're making here today. Thank you.
Thank you. Anyone else speaking? Also, again, were you here last meeting?
No.
No, okay,
No,
thank you. Thank
I
you.
was not. Good evening. My name is Tina Martin. I live at 157 Kings Highway, and I don't have anything so well prepared. I just want to say that I don't know if any of you live in Woodmont, but it's the most beautiful place on earth as far as I'm concerned. It's got a lot of charm and a lot of character, and I think that if we continue to build things such as what seems to be proposed here and what went up recently on, help me out here, Village, with no windows, going back probably 25 feet or 30 feet, we're going to lose the charm and the magic of that very beautiful place. that's about it. So basically, I oppose it, and I feel very strongly about it. And again, this is a charming, special little corner of Milford, and we need to do everything that we can to preserve that. I don't understand what, all the debate is about. It's horrible. Why would we want to do this? That's it. Thank you.
Anyone else speaking?
Good evening. My name is Dolores Hannon, and I live at 110 Beach Avenue. I'd like to reiterate what Barbara read from the letter from Ed Benessi. I think, in addition to what Tina just said, it's very important that the neighbors kind of know what's happening in your community, and I don't think any of us knew. I just got a call last night about it, and so I know the Harringtons certainly are upset, but I think when those kinds of changes are being requested, that the people that live in the neighborhood have a right to have a say, at least in it. So that's a big link to me that's missing here. And also, from what Ed Benessi said, I think it is concerning to try to keep squeezing houses into these relatively small lots to begin with. It's on a corner, it's near the beach. Any of the storms that we've had, Irene, Sandy, that whole area floods incredibly. So there's a lot of safety hazards there, and I'm concerned about that. But I think more than anything, the communication, lack of communication. So I understand, Mr. Tuozzolo, you can't do that much right now, but I think something has to be reconsidered because nobody in our neighborhood knows about it. Everybody's just finding this out.
In respect to what you're saying about, I'm listening to everyone that's been coming up, and this is starting to turn into a planning and zoning, what the planning and zoning meeting would have been. But right now, it's the appeal, the decision that the city planner
So there's
made.
no way to go back to that.
That's what we're, it's about the appeal. And now we're getting everyone's voicing their opinions on what they want and what should be right for the neighborhood. And, we can't make the decision on that.
Right, but is there any way to go backwards?
I don't know. That's, the attorney had started with different ways that she thought we could approach this, but we're just following the guidelines as a board on what we can really do.
Right, I understand that. Right. Well, at least thank you for listening.
And there are people here that'll talk after you, the city planner. There might be someone else, I'm not positive. And they'll explain a few things on how this board can act.
Yeah, I understand
so
that.
We're kind of tied up with
Well,
this.
at least you're hearing what people are saying. And I
True,
appreciate
true.
the fact that I know you all volunteer and you do a great job. Thank you for listening.
So you're right in that respect. We can hear your feelings, but it's like we really can't act on them.
Right, I understand that. But we're making maybe communication better in the city, hopefully.
Thank you.
Thanks.
Anyone else?
Mr. Chair, I just want to clarify 3 things.
You want to let her talk first?
Oh, sure. Oh, I'm sorry.
Okay.
Good evening, Raquel Bonessi, 83 Beach Avenue. David Salke's interpretation of the free split is legal in his opinion. However, in addition to the points previously mentioned, the facts are that 162 Kings Highway was designated as a B1 zone last century, but never was actually used as anything other than a single-family residence since 1910. Furthermore, B1 is an archaic designation used in an old summer shorefront areas like Woodmont, Walnut Beach, and completely out of character with our current neighborhood and the spirit of the zone. Stacy Blake, or Anastasia Blake, is proposing to build literally on Bobby Harrington's lot line, and I feel it would degrade the neighborhood values in addition to possibly safety concerns. I see this in the same manner many saw the battered woman's shelter on Village Road a few years ago, which was legally okay, but not in the best interest of Woodmont or its residents. This combined with the growing 830G issue, I feel the borough needs to draw a line in the sand. And I just hope you take everything you can in consideration. Thank you.
Thank you. Anyone else? Anyone else wanting to speak?
Good evening, Mr. Chair, members of the board. My name is Kevin Crusaden. My office is at 3 Lafayette Street here in Milford. I am the attorney for the applicant, Stacy Blake. She had plans to be out of state this week, so unfortunately she's not present. I don't want to go over everything that's already been said or contradict everything that's been said. I really wanted to just file for the record a copy of the free split map, the application, and other things, because I wasn't here last month and I'm not aware what the board's put into the file, and I'd also like the planning and zoning file to be made part of the record here. And I can maybe clarify some confusion on a few things with the law of what's called a free split or a free cut, and why it's causing an issue with the notice and with the regulations and with the Zoning Board of Appeals. It's because it's a state statute, 8-18, it's the definition of a subdivision. It doesn't actually call out a free split. It actually says, it defines subdivision as more than 2 lots. So if you have a piece of property that meets the lot requirements in the zone, and it has not been subdivided previously, which is the case with this lot, and that's why I presented the deeds and the maps and the title search, you can come to the city planner and ask for his concurrence. In Milford, it would be the city planner, because that's the agent that the Planning and Zoning Board has designated. His concurrence with the facts that it complies with the state statute. So it has nothing to do with the Milford zoning regulations. It has nothing to do with the zoning enforcement officer or the Zoning Board of Appeals. And I know that this board in the past is of the understanding that actions by the Planning and Zoning Board or their subdivision regulations, which the free split's not in the subdivision regulations either, but it's more akin to that type of action, are not heard by the Zoning Board of Appeals. So I don't like to come up and, it's never a good situation to be in, to come up and tell the board, hey, you don't have authority to, or power to act on this. But if you take the timing issue completely aside, which it was filed late, but if you take the timing issue completely aside and remove that from the equation, it's still an action from the Planning and Zoning Board through their executive secretary that requires going to the Superior Court versus the Zoning Board of Appeals. A lot of the comments tonight were about the site plan and the house building and the building permit and the things like that. This is really solely just about the division of the land, which is correct based on the facts. So I would just like to submit a copy of the survey or the lot split, a copy of the notice that was in the newspaper, and I'm able to answer any questions the board might have.
Any questions? No questions so far? Okay. No questions, attorney. Mr. Sulkus?
Mr. Crusaden took all the fun out of what I was going to tell you. But basically, just to reiterate, Ms. Coleman is correct. There's nothing in the in the zoning regulations about this, because again, subdivision regulations are different from the zoning regulations. When I approved this, I did it as the executive secretary to the Planning and Zoning Board, so to appeal that decision would need to be to the Superior Court. The characterization that I slipped in this free split is inaccurate and quite simply not true. It is true that I met with various neighbors regarding this property and its status when it was being processed through the office as a subdivision, because at that time we thought, gee, this is going to be a re-subdivision of a property. And at the very end of that process, Attorney Crusaden discovered that the properties have never been split, provided the state-required information to make a judgment on it, and then I made the judgment. So unfortunately, the neighbors who thought they were going to have their quote-unquote day in court to protest the subdivision, they weren't able to do that. And that's unfortunate for them, but for the applicant, they had a legal right to ask for the free split, and the information was provided, and I concurred with it. And that's simply in a nutshell. So once again, this is the wrong venue. If people did not like the free split decision, it should have been appealed to the Superior Court.
Anyone have any questions for our city planner? No? Okay. Attorney Coleman, you can have the last word.
I stood in front of you, and I gave you very specific regulations and state statutes. I quoted the numbers from both the administrative aspect of the planning and zoning regs and the Connecticut general statutes. I keep hearing that we have to go to Superior Court because of the Connecticut statutes. Please tell me what Connecticut statute you're referring to, because I'm not seeing it. This 8.8 clearly states you can go to the Superior Court after the planning and zoning decision, or if you have a ZBA, you can go to a ZBA. 8.8, I guess I should have given you a copy of that. Again, I still say you have jurisdiction. To me, it's a question of law, and you really should talk to your attorney. I believe it's Attorney Burcham from Burcham and Moses. Because I have not heard anything that tells me the statute. I got the book here. Please, tell me what statute you're referring to, because I can't find it. That's why I brought this book, because I keep hearing people say, Connecticut statute, Connecticut statute, Connecticut statute. I read the statutes, and I do make mistakes. That's why I brought it, in case I made a mistake. I didn't so far, because I've heard neither Attorney Crusaden or the city planner give me the state statute they're referring to. In a court of law, you would have to give that statute. Why is this any different? Because this is a legal question. Who has jurisdiction is a legal question. And city planner said there's nothing in the zoning regs about a free split. How would my clients know where to go in the zoning regulations? You have to put people on notice. You have to. It's called procedural due process. And our zoning regs are seriously lacking. I guess I'm frustrated, and I'm looking for you, because I do believe you have jurisdiction, and I do believe you need to talk to your attorney. And I do believe that the city planner made an erroneous decision when he allowed this free split. He is not an attorney. He is not a judge. There's 36 feet frontage for building. They need 50 to free split it. So again, I implore you to talk to Attorney Burcham. I believe he's corporate counsel for the ZBA, and ask him about the issues that have been brought up tonight. Please. Thank you.
You know, in this, we put this off for a month, and I had hoped in that course of the month that you would have approached the city attorney.
You know what? I really don't practice a lot in zoning, but I love an interesting issue, and this is a really interesting issue. So I'm not completely familiar with what my expectations were. Maybe I should have called you and asked you if you wanted me to go talk to him. Because I think he would want to guide you and protect you in this decision. I don't know any of you personally. I don't know your background. And so I think he got notice that this is on the docket. I just don't know how it works with you guys. If you want me to call him, I will.
Well, we're going to make a decision, actually, I believe, this evening on whether or not to uphold the decision, the city planner's decision, or overturn it. So that's where we are right now.
And when do you make those decisions? After, do you go into executive session? Should we all wait around, or you give us a written decision?
We're not going to be in executive session. It's right here, right now. We'll have our discussion and we'll have our vote. We don't, we're not going behind any closed doors or anything like that.
Thank you, we appreciate it.
Mr.
Okay.
Chair?
Any other comments?
Just very quickly, the comment came up, what statute? Section 8-28, Notice of Decision of the Planning Commission. That's the appeals process that sends you to the Superior Court. Once again, I was acting as the executive secretary to the Planning Commission, so I am the Planning Commission when making that decision. That's the statute that sends it to the Superior Court. It's quite clear.
Okay, thank you. No further questions on this board? Okay, okay, this hearing's closed. So, okay. We've heard, of course, Mr. You ready? Mr. Hirsch, you have a comment?
I just want to hear what you have to say, Joe.
Well, it's as simple as I just told Attorney Coleman. Either uphold the decision of the city planner or overturn it. And, you've heard the pros and cons on what we can do. I stated last month, and I'm stating again, that the ZBA, we don't have any authority to overturn what has been put forward on this issue.
Well, she was counsel for the appellants was using terms like jurisdiction and saying it's a legal question. She's saying free split is a legal question. She's bringing up due process. She's bringing up declaratory judgment. Those are terms you don't find here at the ZBA. You find that at Superior Court. That's probably the better venue.
All right, so it gets back to this was a timely issue and it wasn't brought to the Superior Court.
Whether the issue is timely or not, the proper venue to challenge the decision of the executive secretary is the Superior Court. So either way, if we uphold it or deny it, it's going to go to Superior Court no matter what.
Okay. Any other comments?
The thing I hold issue with here is, are we setting a precedent here for the first time with this free split, provided the narrowness of the two homes on the lot? Because if we allow this, then what's to come?
Well, I don't have an actual answer for that question you have, but right now we're talking about appealing the decision that the city planner has made, and not the situation of what is, a free split would cost. So, any other comments? If not, we need a motion either way. Mr. Dubois, did you have something that you wanted to add? No. Ms. Ferranti? No. Anyone ready to make a motion?
Yeah, I'll make a motion. Motion to uphold the decision of the city planner.
Okay, we have a motion to uphold the decision of the city planner. We have a second on the motion. Mr. Hirsch?
With the motion.
Mr. Casey?
With the motion.
Ms. Ferranti?
With the motion.
Ms. Falcott?
Against the motion.
I'm with the motion. It's upheld.
Item number 3, 47 Cherry Street, MBP 66/817/16, RO Dina Lieberman for MD Acquisitions LLC, owner. Vary section 5.3.1.4, ground sign setback to 4 feet where 10 feet required.
Hi, good evening, Board. Happy holidays to you. I appreciate your time tonight. I was told not to overthink this, and I was kind of, so I almost didn't. I am the co-owner of MD Acquisitions. We purchased the property at 47 Cherry Street. It's a 1905 building. We restored it to its original beauty, and we have a office, which is our office is On the Mark Management, Property Management Company, and Real Estate Brokerage. We are asking for a variance at the front of our property. We did a survey. We were told that a 10-foot back from the property line was...
Excuse me, can I just hold you up for 1 minute? Just as soon as the noise...
Oh, sure.
goes. If you would, please. I didn't want to interrupt you, but it was hard to get your points
okay.
across. So go ahead. I'm sorry, continue.
Okay, so we're right in the center of Cherry Street, which is, again, commercial, mostly commercial, up and down the road. We're between Gulf Street and downtown where the Five Corners are, that West River Street. We have just joined Weichert Realtors, dash On the Mark. We are going to be an independently owned and operated franchise with Weichert, and due to this fact, we were told by them, of course, that we needed signage for our property. It's a 1905, as I said, and it was built prior to zoning for the variances that are now, of course, instated. Our property line from the front of the property to our porch is about 10 feet. Up and down this road, as you see, it's been quite often that most signs on Cherry Street are almost, well, I actually measured every single one down the street. They go from anywhere from 2 feet to 3 feet to 4 feet to 6 feet. Because our yard in front is narrowed towards getting towards downtown, we're requesting that we have our sign about 4 feet in where that 10-foot is required. The sign itself is within all of the standards and the regulations required by the board. It's, I guess they call it 9 square feet, but it is a 48-inch wide by 32-inch long sign, and it's about 64 inches high. I do have 2 photos. Well, I have a photo and a picture of the sign. It shows as close to scale as I can get it, what this would look like, which it is in, I want to say, in the same feeling of what the street already currently has. In fact, it's almost a match for several other styles of this exact sign down the street. Another reason we're asking for the variance is that there's an amazing copper beech tree coming from downtown towards us. There's the most beautiful copper beech, and its trunk is so big that, of course, any viewing of the sign would be interrupted by the tree coming from downtown. But we're trying to make it, as I want to say, as our company a little more visible to the passersby, and not be ostentatious in the size or the scale of the sign. But we do need it a little bit further because our porch steps come down 4 feet out from the porch. So again, it's sort of a hindrance for viewing and noticing our business as you pass by.
Okay, any questions? Go ahead.
I ask this of everybody, what's the hardship?
The hardship is viewability and noticeability that we have a sign. We currently have our sign up on our porch, which is not perpendicular to the road. So unless you're right up on the front of our building, that's when you have to turn and see that there actually is a business there. So we are just asking for something that everyone else has on the street ahead of us. is visibility and viability of showing, you know, that we are currently a business and would like to draw attention.
Right, but is the hardship, so is the lot too narrow? Is
Oh,
the
yes,
lot
sir. I'm sorry.
Uneven? Give me something about the property that creates a
Well,
hardship.
the property, I believe it was filed, it's 0.35 of an acre, but most of it is at the front of the property. At the very front of our building, I believe it's only, hold on a moment, like, it's so tiny I can't see it. I can't see the front numbers here, but because of our driveway, the sidewalk, and then our sidewalk to our front steps, we only had, and because of also the plantings in front of our porch, which come out about 4 feet, we only have a space of, I don't even want to say, 10 feet to work with.
So it's a very narrow lot, is what you're saying.
Heck yeah.
Thank you.
It is.
Can you tell us again, you said that you measured the distance from the property lines of the other houses on the street where their signs are? Can you tell us
Yes.
what those distances are again?
Well, Harmony Place is right next door to us. I believe their sign is about 6 feet in. The very brand-new Metro Star property directly across the street from us, their sign is about 2 feet, not even 2 feet, it's like 22 inches from the sidewalk. Now, I don't know where their property line starts, but as I understand it, the sidewalk is the property of the city. So it starts on the other side. They are very, very close to the sidewalk. I measured down at a dentist office, which is a new sign also, and they were about 2.5 feet in. So all down the street, and it narrows even further towards West River in the 5 corners.
Okay, any other questions? Anyone else speaking in favor of this application? Anyone here opposed to this application? Any further questions?
Mr. Chizola, there was a letter submitted this afternoon in opposition from the Harmony Place Condo Board.
You have the letter? Do you have the letter?
That was today?
Is it a long, lengthy letter?
No. It's
Do
addressed
you want to read it?
Sure.
Okay,
if you'd like.
okay. Because we have a letter, we're going to read it into the
Okay.
record.
Should I stand here?
Yes, please.
Okay.
Okay, the letter was erroneously addressed to Mr. Sulkus, city planner. It says, it's from Harmony Place Condominium Owners Association. Dear Mr. Sulkus, the Board of Directors at Harmony Place Condominiums, which is located at 51-67 Cherry Street, is in opposition to the request made by MD Acquisitions LLC for a sign variance at 47 Cherry Street. This would waive the 10-foot setback ordinance for signage. We feel this would be a hindrance to residents and visitors of the commercial businesses exiting adjacent properties. Cherry Street is a busy street already, and affecting the vision of drivers going onto Cherry Street would create a safety issue. Please relay this opposition at the Planning and Zoning meeting scheduled for December 11th, 2018. Thank you, Edward Burns, the 4th President.
So actually, the sign is going to start 4 foot in from the sidewalk.
Yes, sir.
Okay. Okay, anything else? No? Okay, this hearing's closed. Oh. Would you like to speak in favor? Okay.
Who are you?
I
Wait a
couldn't
minute.
let that go
Are you familiar?
unchallenged.
Are you familiar with Cherry Street?
Just for the record, Mr. Chairman, Thomas Lynch, and I'm an attorney here in Milford with offices at 63 Cherry Street, 3 buildings down from the subject property. And notwithstanding the letter from the Board of Directors of the Harmony Place Association, I am the owner of my building, and I'm in favor of this application. I will state for the record that My ground sign in front of my law office is approximately 3 feet off the sidewalk, and I think that the applicant has a clear hardship because of the existence of the copper beech tree. So I'd ask that you approve this application.
Okay, thank you. Okay, this hearing's closed. In traveling and looking at our, what we usually do before we have our hearings, I was wondering also, when it was brought up, there are a lot of signs along Cherry Street that I'm wondering why they never had a variance. But I guess they're there now and it's too late, so. Any comments or we need a motion?
I think that the placement of this sign, as stated, is in keeping with the other signs along the street. And I've come in and out of the businesses on Cherry Streets, and I've never had an obstruction of my view because of these signs.
Would you like to make a motion?
I make a motion to approve this application.
I second.
A motion to approve. We have a second on the motion. Ms. Falcott?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Hirsch?
With the motion.
Mr. Casey? I'm with the motion. It's approved.
Item number 4, 296 Broadway, MBP 9/130/11, R7.5, Michael Brewery, owner, vary section 3.1.4.1, northeast side yard setback to 2.9 feet, where 5 feet required to construct attached garage.
Good evening. My name is Mike Brewery. I live at 296 Broadway in Milford, and we're looking for a variance on the side yard. Right now, there's about 5 foot, I think, is required. We're looking at a variance to allow us to go out 2.9 feet, as opposed to 5 feet. We're looking to put a garage on the property. It's a very narrow piece of land that's there. We have very limited parking. We have very, very limited parking. There's no parking on the corner. We live on a corner. There's no parking at all there. And we're going to lose a bedroom inside just so that we can have additional parking. And the garage will help us preserve and protect our vehicles. We're sitting outside and getting sandblasted, and the salt is very corrosive, so we're asking for the variance on that side for the garage.
The existing house is actually 2.91 or 3 foot. So this is just an extension of the nonconformity.
Yes.
And looking at this, you're 20 foot in from the corner. So, any questions for this gentleman? No? Anyone else? Anyone here speaking in favor? Is there anyone here opposed? Anyone here opposed to this application? Any further questions? This hearing's closed. Okay. It's pretty simple. What do you think? Make a motion.
Motion to approve.
Second.
Please state your reason.
I'll say the narrowness of the lot, and that's the hardship.
A motion to approve. We have a second on the motion. Mr. Hirsch?
With the motion.
Mr. Casey?
With the motion.
Ms. Ferranti?
With the motion.
Ms. Falcott?
With the motion.
I'm with the motion. It's approved.
Item number 5, 16 Ross Street, MBP 66/813/22, CDD1, effective 12/17/18. Thomas Lynch Esquire for J.E. Rogers, owner, vary section 3.16.4.24, buffer strip adjacent to residential zone, 20 feet required to 5 feet provided. Section 5.14.6.5, landscape buffer from 6 feet required to 0 feet provided. Section 5.14.6.6, 10-foot buffer required to 5 foot provided. Section 5.14.6.7, landscape area 4 feet required to 0 feet provided. Section 5.14.6.8, landscape area 5 feet required to 0 feet provided.
Good evening, Mr. Chairman, members of the board. Just for the record, my name is Thomas Lynch. My office is located here in Milford at 63 Cherry Street. And I'm here tonight with Brendan Gallagher and Lorenzo Candiotti, who are the managers of the Russell Speeder Car Wash. Russell Speeder RCW Management is the owner of the property located at 263 Cherry Street. And the company is also the contract purchaser of the property located at 16 Ross Street, which is directly behind the car wash property. My clients are before you tonight to very pertinent sections of the regulations as they relate to the buffer under Section 5 of our zoning regulations required between commercial properties and residential properties. And also there's a number of variances that we're seeking of the sections under Section 316, which require site elements to have certain landscaping and buffering requirements as well. So just by way of background, my client has operated this property as a car wash for over 30 years. I think you're all familiar with its location at the corner of Ross Street and Cherry Street. And I think anyone who lives in Milford is also familiar with the traffic problems that arise, especially during the winter months, with the high volume of cars being washed because of snow and ice and whatnot. But what this plan is to expand the car wash. We appeared before the Planning and Zoning Board last month. The Planning and Zoning Board approved an application to change the zone classification for 16 Ross Street from R5 to CDD1, which is the commercial zone that extends from Cherry Street along the Post Road out to the town line in Orange. And to then come back to the zoning board with an application for site plan review, we need to have these variances granted by this board, basically to recognize the nonconformities that exist on the existing site, but also the portion of the car wash that's going to extend onto the Ross Street site because of the nature of the 2 lanes that are proposed on the property. So right now there's a single lane that comes into the car wash. There is detailing that's done on site, and the detailing is going to be removed. Cars that are parked on Ross Street are going to be removed as a result of that. And the second approach lane is going to come up to the car wash facility. So this is really going to alleviate the traffic problem. We think it's a great improvement for the area. But for the site plan to be zoning compliant, when we go back to the Planning and Zoning Board with an application for the site plan review, it necessitates this board entertaining our requests for the variances and granting them. Specifically, under the buffer that's required between a commercial property, now that the zone line is changed back to the western side of, the eastern side of 16 Ross Street, the buffer then would be between 16 Ross and 20 Ross. There was a residence that was located at 20 Ross that's been demolished. The proposal is to have a 5-foot buffer along with a stockade fence to create the buffer between 16 Ross and 20 Ross. And with a strict reading of Section 316.42 of the regulations, that calls for a minimum of 20 feet, except if there's 10 feet that is provided. The board may, meaning the Planning and Zoning Board, may allow a berm or a fencing to substitute. So the request here is to basically have the 5-yard buffer, the 5-foot buffer instead of the 10-foot buffer, but the plans do provide for a stockade fence to be between those 2 properties. The other landscaping requests are basically due to the fact that the vacuums are located along the property line where Ross Street is, so that it would entail removal of those vacuums. We believe that creates a hardship, and coupled with the narrowness of the lot, there's no other way to really reconfigure the 2-lane approach to the car wash building to reach the goal that my clients want to do in improving the site. So in summary, what we're asking for is to basically recognize the nonconformities that are there, to allow the slightly diminished buffer between 16 Ross Street and 20 Ross Street, but recognize that this is going to improve the area, it's going to alleviate a traffic problem that's existed, and we think it's something that's a win-win for everyone in the area. I'm happy to answer
So
any
this was
questions.
pre-approved by the Planning and Zoning.
The zone change
Yeah.
was approved.
Okay.
We
So-
do have
so
to go
you just
back.
need- We need the variances to go back and have the final
Correct.
confirmation on it.
The site plan going back with an application for site plan approval has to be zoning compliant. This is after long discussions with David, who's sitting here tonight. And this was the sort of the path we charted out, and we did get the zone change approval. Hopefully, you'll grant these variances, and then we'll go back for final site plan approval.
And the safety issue is you're going to get more cars off the street.
It's going to be about 24 cars that'll now be on site versus 12 currently. So it's basically doubling the amount of cars that can be serviced on the site. And as well, if you've gone to the property, there's a rather, without disparaging my client's property as it currently exists, there's a rather unsightly shed that is there for people to wait while their cars are being detailed, and that's going to be removed as well.
There's no structural change to the car wash itself, it's everything surrounding it.
Correct. There's no additional construction planned.
Okay, thank you. Any questions? No questions? Okay. Anyone else speaking in favor of this application? Anyone here against this application? Come forward if you have some.
Apologize if I seem a little misunderstood. My name is Poppy Siderwick. I live at 20.
Can you pull the microphone down and
Sure,
start
sorry,
over?
I forget I'm small. I'm Poppy Siderwick. I live at 26 Ross Street, and so pardon me for being a little confused because the last notification I got about a zoning meeting, the meeting was canceled when I arrived. So I wasn't aware that the property zoning has actually already been changed to commercial.
It wasn't this meeting that you had missed because it's the first time it's before us.
Okay,
It was
so-
brought to the Planning and Zoning.
So we had received a certified letter saying that there was planning and zoning meeting to change the zoning classification of 16 Ross Street. When I arrived at that meeting, there was a note on the door, which I have a picture of, that says the zoning meeting was canceled. So I was not aware that the zoning for 16 Ross Street had changed. And so I'm taken aback by that because this is the first I'm hearing of it, because I received a letter telling me to attend this meeting, which I assumed was to discuss the zoning change. And so I just want to raise some concerns because while I have no issues with the car wash being where it is now currently, but I do almost get hit by people exiting from the side at least once a month, and that's from the side coming onto Ross Street. Not to mention the cars that block the street because there's only one half of the street that can be parked on. Not to mention the fact that 20 Ross Street was demolished, which understandably so because the home was falling apart. However, it's become a parking lot for members of the dental office, even though we were told it would be a house and no one really asked our opinion about it being a parking lot. But because apparently there's no asphalt or lines, it's deemed it will someday be a home, to which I ask when. So at this point, I live next to a vacant lot, and now you're telling me you're extending a car wash further into my street that people already think when they exit the car wash isn't actually a street, so they tend to block me in when it snows anyway and yell at me and tell me that it's one way. So I'm a little concerned as to how this impacts me as a resident on a small residential street. It is not a large street, it is small. There is limited parking as it is, and not that I'm having huge extravagant parties, so trust me, I'm not. But I do have concerns as to what it does to my property value. I have concerns as to what it does for when I look out my window and I see a vacant lot followed by now a car wash that people who are exiting the car wash can now peer into my home, because unless I want to block all the sunlight that comes into my house, everything is visible. And so I'm just a little confused and concerned. And while I understand these are variances about all kinds of, landscaping and all that great stuff, I just don't understand when the zoning was changed and why we weren't notified of the change. Because I have to tell you that I have 2 letters, one that was certified telling me of a date to which I arrived and there was no meeting, and another letter that I received notifying me of this meeting. So I just want to voice concern on behalf of myself and what I currently live at.
We're going to address the variances, whether or not they're approved or, or not. And there's going to be a follow-up meeting with the Planning and Zoning Board. At that meeting, you can go and voice your oppositions, because that will be the final confirmation of the application.
Sure.
So I'm assuming, when do you think that would be, the Planning and Zoning meeting? Any idea? Within a week or probably next year?
It'll be definitely next year. But, it's going to depend on the applicant and when they put together their full application and do all the things they need to do. But there's probably not going to be, we have one more meeting this year, which is probably not going to take place because of the holidays. So it'll be probably next year.
It'll more than likely be the first Tuesday or the third Tuesday of each month. So.
Will I receive notification, or should I just monitor the agendas?
Okay. We'll ask Attorney Lynch on how you'll be notified on that, okay?
Okay, thanks.
Sure.
Ma'am, before you leave, can you just repeat your last name, please?
Sure, Siderwick,
Can you spell it?
S-I-D as in David, A-R-W-E-C-K.
Thank you.
You're welcome.
Seeing as there's only a few houses on that street, I don't think it's going to be a problem notifying you, so. Mr. Lynch.
Yeah, just to address a couple of those things. I believe what happened was there was a canceled meeting, and Meg can verify this, but the meeting was opened.
Lack of
It was
quorum,
a lack
I
of a
think.
quorum, so everybody that was here that night was told it would be re-advertised and everything would be put off to the next meeting. But then going directly to the concerns that she has, again, I reiterate that the majority of the parking of the cars on Ross Street is a result of the detailing that goes on the site now, and the detailing is going to be removed. So it's just going to be cars coming in, going into the car wash facility and then coming back out. So hopefully that'll address some of the concerns on the Ross Street side.
So no more detailing services, just
That's
washing?
correct. Just car washing, yep.
Yes, sir. If you'd like to speak. Are you in opposition?
I live on the same street, Ross Street, and I really had time to, Santiago Gilbert. Gilbert Santiago. I live on the Ross Street as well. Yeah, like you said, there's only 3 or 4 houses. I'm on 38. I'm actually at the end. So I really didn't get a chance to really study the in and out. Like she mentioned, I was concerned about the same thing. People going in, coming out. It can be frustrating at times. So I still want to see the in and out, where they go in, come out. I think they're going to go in from Cherry and come out of Cherry. I'm not sure on that.
Well, all the cars always exit because they go through the car wash. That's how they come out, usually.
Well, there's a side.
What is the additional traffic from then? People vacuuming their cars and?
Is Ross Street now closed?
Well,
No, the site plan is going to have the entrance coming in off of Cherry for people to come up to the vacuums and then get in line. Yeah. Sorry about that. Here, come on over here. I'll show you. So right now, the entrance is going to stay the same, obviously, off of Cherry Street. And right now, there's an entrance off of Ross Street. That's going to be removed, but then it'll be put at the further eastern end of the property, just for people who get their car washed, then go to the vacuums, and then they back out onto Ross Street. So that will still have a curb cut there.
Well, okay, you say it's going to alleviate traffic, but I don't. How do you come up with that assessment, traffic? Because more Or is it gonna be because, like, the detailing is not there and there's gonna be people, it's gonna be in and out, basically, is that?
Right. In other words, right now, there's, as you know, there's a lot of cars that park on Ross Street. Those are cars waiting to be detailed. And I've been on the site many times where I've seen maybe 4 or 5 cars actually backed down Ross Street. That's going to be eliminated because there's not going to be any detailing done on the site anymore.
Okay, I guess that's good for now. I'll just study more and see what happens from there.
Again, there's going to be a planning and zoning meeting, and you can go to that meeting, because that's the night that they'll be voted on whether or not it'll be approved. So we're doing the variances here right now.
Okay.
Okay?
All right, thank you.
Anyone else speaking in opposition? Attorney Lynch, you have anything to conclude? Nothing? Okay. Any questions? Okay, this hearing's closed. Well, if you look at the plan, they're going to get more cars off the street. That's a safety issue. Go ahead.
The issue I have is, and maybe it's a little off topic, but I've heard 2 people coming in here today talking about they're not getting sufficient adequate notice from hearings. And, yeah, I'm all for, I'm all for this, for this proposal, because I think it's a safety issue. But we have 2 people coming in, 2 residents of Milford coming in saying they're not getting notice of hearings. And I'm saying from planning and zoning. I'm just saying about, not for this hearing. I'm just saying in general, we've had 2 people come in here and say that they're not getting notice for hearings, and I think we need to address this.
And those are not the only instances in the last year or so.
This is becoming a recurring theme, and, you know, once is an accident, 2 is a pattern.
You know what? We have new business coming up. We can discuss that in new business, if you'd like. But
Great.
right now, we should finish up this hearing.
Okay, well,
And then let's spend a few minutes in discussing then how people are notified, so.
I mean, with regards to this application, I mean, you have a commercial property next to a residential zone. I'm not sure that you can ever fully alleviate the traffic from the commercial property entering the residential street, but it does seem as though this is going to alleviate some of the congestion there. I mean, people will be coming and going, but no one will be parked waiting for services, which should break up some traffic in the street. So it sounds like a positive improvement to me.
Yeah, I think that any changes that they're going to be making are going to be, you know, for the better.
I mean, those were my thoughts on Ross Street. Now, on Cherry Street, I've been stuck in traffic, which is just a line of parked cars in the road waiting to get in. So if that goes away, I mean, I think it should break up congestion in the whole corner.
Okay, so this hearing's closed, and we need a motion.
A motion to approve the petition.
Second.
Yes, the reason is the alleviation of a safety hazard to the citizens of Milford.
The motion to approve, we have a second on the motion. Mr. Hirsch?
With the motion.
Mr. Casey?
With the motion.
Ms. Ferranti?
With the motion.
Ms. Valakut?
With the
I'm
motion.
with the motion. It's approved. Okay? You're welcome. New business. Okay. What do you want to talk about in new business? Notification, how people are being notified.
Register. That's unacceptable.
Okay.
I mean, the Milford patch, online, there are so many
I don't think we notify anybody through online sources. Do we? Internet or any of that?
No, we don't.
We don't.
We use the Milford Mirror, and when they're not available, we use the New Haven Register.
So the
And
thought being is, what
the
do we do?
abutters, the abutters list comes from the assessor's information, and the notifications go out to property owners within 200 feet. So if someone does not own property, they won't get a letter.
So the people within 200 feet, if they get the letter and they don't notify anybody else in their neighborhood, and a lot of people probably don't, that's where we're missing out, maybe. I don't know. Myself, I don't think the New Haven Register is a good source with today's way of getting information out, but I
Well,
also don't think,
Be that as it may, Mr. Chairman, by law, we have to use a newspaper.
Correct. Right. It's by statute.
The other thing I'd like to kind of toss into the ring is that the notification requirements, depending on what the application is, can be different from ZBA versus planning and zoning. So those were kind of getting mixed together this evening as well.
And again, the notifications that the Planning and Zoning Board uses are again by statute. So people might not like it, but we have to follow the law.
What exactly happened tonight? She received a letter for the planning and zoning meeting. She found a note on the door that it was canceled, and how was she then supposed to next be notified of the rescheduled meeting?
That particular case, that was for a zone change. It's the only thing the Planning and Zoning Board does that requires notification that's similar to this board, where the applicant has to notify the property owners within a certain distance. So she got her one notification from the applicant regarding that meeting. That meeting was canceled. We were actually still here because we were waiting and waiting and waiting to see if we got a quorum. It's the first time that's happened in 15 years where the night of the meeting we didn't get a quorum. So as I explained to her, I said, you know, you have to monitor the agendas online, which we place online, because automatically if a meeting is canceled, whatever's on that agenda gets moved to the next agenda.
Well, was that included in the sign on the door that the meeting was canceled? How is someone who's received a letter in the mail then supposed to know they're supposed to monitor online forums when they've never been told to do so?
That's an excellent question. I don't have an answer for you, other than, you know, as I said to the lady, I said, you know, always, if you have any questions, always call the office, because, you know, we can give you that information.
Okay, anything else under new business? Old business? We don't have any old business, great. Staff update? No new staff, okay. Acceptance for the November 12th hearing? Everyone read their minutes, everything's okay? Your names are spelled right and everything? You did everything right? Okay.
Trying to check if
Approve the minutes, all in favor?
Aye.
Aye, okay. Applications for next month? How are we doing for next month? None. Wow.
Rock Street, assuming.
Which might go away? Okay. Okay, motion to adjourn? Anyone want to make a motion to adjourn?
I make a motion to adjourn.
I second.
Okay, this meeting is adjourned.